Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. Today, one ransomware attack that has led to possibly over $5 million in liability for this MSP. We're going to talk about lessons that you need to know. Now, if you have any medical clients, if you're a business associate, if you've signed a BAA, please watch to the end of this video. I have not monetized my channel. I'm just trying to give free information and considerations to you guys. So please watch through the entirety. At the very end, I'll give you some additional considerations and action items moving forward that I want you to consider. So what generally happened here? One, allegedly, a Russian ransomware gang hit an MSP's data center. Patient records got stolen. The ransom amount comes in. The MSP is now facing unlimited liability in federal court. So I have answered this question. I've jumped in multiple times on Tech Tribe. If you're not joined, it's an awesome place. You should check it out. I've answered this on the MSP subreddit where some MSP is going, hey, I got this really sweet deal. This guy's ready to sign, but they want me to take out my limitation of liability provisions, or they want all of these additional things in their benefit. Please be super careful doing that, because at the end of the day, you're probably going to be held to that contract. So not every client needs to be your client, and never let your client's risk tolerance exceed your own, and never agree to unlimited liability. That is a potential disaster waiting for you. Now, a plot twist that you're going to see in the middle of this video, the MSP has dropped the nuclear defense. I've never seen this before. I really hope they know what they're doing here, because if they're wrong, they're going to get absolutely demolished. So let's go through the actual contract, the actual lawsuit, and the defense, so you don't have to be in one of my videos in the next couple months. Let's talk about the players real quick. First, you have molecular testing labs. I'll just call them MTL. They handle the PHI at scale. Now, the original IT company, they got acquired. Then the acquiring company got acquired again. So if you go back, this BAA got signed in 2018. That's 7 years ago. So if I was a betting man, I would say, well, the M&A sphere for MSPs kind of plays fast and loose. I would bet that the ultimate company that got served with this lawsuit probably didn't even know that this BAA even existed, or it had never been reviewed, because if it had, with legal counsel, they probably would have said, hey, you really need to renegotiate these terms. Now, MTL, they sent this formal indemnification demand. What does that mean in human terms? Hey, MSP, pay up. You owe us unlimited money. The MSP allegedly went silent. April 2025, the suit got filed. Mediation window is already closed. So now we're probably looking at trial or judgment. A quick note on BAAs and MSPs. Now, HIPAA requires a BAA anytime a covered entity shares PHI with a vendor. So if you're dealing with hosting, backup, storage, security, IT support, etc., you are very likely in business associate territory. Now, I'm not your attorney. I'm not providing official legal advice, but if you're providing services to a HIPAA regulated entity and you have not signed a BAA, you might want to get some legal counsel on that, just to make sure that you are not on the hook for this. Now, in my experience, many MSPs just sign whatever the client puts in front of them, because they're like, hey, if this is what I got to sign to get the MRR, deal is done, let's make it happen. You really need to be careful about that, because BAAs are liability documents. And that is what has led this MSP to effectively unlimited liability forever. And this is a huge, huge potential bill they're going to pay. Now, in this case, you'll see just a train wreck of a BAA. So no liability caps, no damage exclusions, no comparative fault provisions. Not a good place to be. Now, this is the actual indemnification clause from the BAA. You're welcome to pause the video and read the text while here, but it's effectively saying, hey, if the MSP is negligent and PHI goes out the door, guess what, MSP? You're paying for everything forever. You probably don't want to do that. Now, the security requirement. pretty straightforward. Administrative, physical, technical safeguards. Nothing new there. Full HIPAA security rule compliance is mandatory. You got to report any security incident, no materiality threshold. Now, there is a HIPAA risk of harm analysis with the 4 steps. I'm not trying to give you a full rundown of HIPAA here, but these obligations apply equally to the MSP as well as the covered entity itself. Now, the BAA negotiation failures, we already talked about some of them, but one, man, no liability cap. So ideally, it's going to be tied to some amount of fees paid. It's like 3 months, maybe 6 months. Please don't just put down whatever your limitation of liability is in your tech E&O policy, because remember, tech E&O is half E&O, half cyber insurance. So if bad guy gets into your system and then gets into your client's system, well, your cyber is going to pay out. So that's diminishing the limit of liability. You might be on the hook for a whole bunch of money that is no longer in your insurance policy. So please be careful about that. No consequential damages exclusion, no comparative fault provisions, no defined security framework to say like, hey, what's actually satisfying this BAA? No audit notice requirements, and the cure period was only 10 days before termination right kicks in. So not great there. What do you think happened when this contract met a real ransomware and data breach event? Well, you probably already know from the title slide there, it's not great. So what this looks like is the covered entity's attorney, he just put it in his wish list and then got no pushback. Now the MSP is going to be paying potentially $5+ million for this. Now the lawsuit, according to MTL, so these are allegations made by MTL. We'll talk about the response here in a sec from the MSP. But March 12th, 2025, hey, they discovered the breach. So they immediately reach out to forensics and they reach out to the MSP for help. Now, according to MTL, the MSP's response, well, they failed to provide meaningful assistance for weeks. Support was eventually offered, but it was slow and described as incompetent. And at one point, they told MTL, hey, we're going to have to charge you extra for breach response. But the BAA included a duty to mitigate, so now that is up for litigation as well. Forensics findings, according to MTL, what do you think happened? Hey, they confirmed, yes, PHI was breached. They identified specific HIPAA deficiencies in the MSP systems, and they said those same deficiencies allowed the breach of MTL's own system. So at least from this perspective, it looks pretty damning. They concluded, yep, the breach was directly caused by the MSP's failures. Not great. Now, what does MTL want? Well, hey, breach of contract. MSP, you're going to pay for everything forever. Also, because MTL is staring down the barrel of a litany of class action claims, they want the court to declare effectively, hey, the MSP owes us for future damages too, aka all of these class action claims, and the court has ongoing jurisdiction to make the MSP do this. So this includes pretty much everything you'd imagine: attorney, forensics, breach notification, credit monitoring, third-party lawsuits, reputational harm, which how do you even put a number to that if we're talking about forever? But the MSP's fighting back, and it's pretty wild. So before we get into that, this video is brought to you by CCA Lawyers for the Situation. They deal with tons and tons of MSPs, helping out with MSAs and SOWs. So if you want a law firm, go ahead and check those guys out. If you're like, hey, I just want the MSA and the SOW, I don't need a law firm, or I already have an attorney, go ahead and check out xclause.com. Now let's jump back into it. What was the MSP's response to this? Well, unsurprisingly, they pretty much deny virtually everything. They deny the location of the breached data center, which I thought was kind of comical. They're like, hey, it's not even in that city. They said the BAA language was misleading, which, I don't know. Reading through it, it seemed pretty straightforward to me, but we'll see how that goes. And then they dropped the nuclear defense. And man, is this interesting. What was it? The MSP goes, hey, the servers potentially impacted in the data breach were not even under our care, custody, or control at the time of the data breach. And as such, we cannot be held liable. bold move. I hope they did their homework, and I hope they're right, because, man, that could be a slam dunk, or they are about to get absolutely dunked on by the courts. So we'll see how that one plays out. Now, ultimately, this could mean a whole bunch of things. It could be like, hey, MTL already migrated away from the MSP before the breach. It could mean the services under the BAA ended, even though that contract was still active. It could mean the MSP decommissioned those systems before the event. It's vague, but bold. So keep in mind that BAAs can still be enforced even after the client leaves, because there was, as far as I saw, no termination provision in the BAA. Now, they did include 27 other defenses. I will not bore you guys with all the details, but it included, hey, man, the hackers did it, and that's beyond our control. MTL's own conduct caused or contributed to the breach. Now, remember, we said before, there was no comparative negligence provision inside of that BAA. MTL failed to mitigate some of these damages themselves. And there was this offset recoupment idea where maybe MTL still owes the MSP money, so maybe there's going to be a counterclaim here. We'll see how that goes. The lesson is, hey, when in doubt, man, just plead everything and hope to goodness that something sticks once you get to discovery. But you don't want to get to the point where you're going through discovery. So what's going to happen next year? Well, we got to find out. Were the MSP services active even at the time of this event? The MSP is going to go after MTL's HIPAA compliance record. So they're probably going to try and make some of that comparative fault argument. Both sides' security practices are subject to discovery. So you're going to want to keep that in mind at the very end here. I'll give you a pointer. Refusal to help and extra charges, that's going to be in the record. The MSP's internal communications, man, that could get spicy in discovery. So quick little lesson here. Always talk like grandma's listening, and it's going to end up in front of court. All right. Now, why MSPs lose these types of arguments? One, hey, ransomware targeting healthcare, it's well documented, it's foreseeable. You have a duty of care to try and mitigate that. We didn't know we were vulnerable. HIPAA requires these ongoing risk assessments, so you can't really have the ignorance defense. They can't really probably say the contract was too harsh because both sides here are sophisticated entities. Now, if you had the company got acquired and that acquiring company also got acquired, well, yeah, these are sophisticated entities. This is a large MSP, and they probably just should have had an attorney look over all this stuff before they started buying other entities. Hey, we sold the company. Well, the BA assigns and binds two successors. So that's probably not going to work. And they're saying, hey, the servers were not ours. Well, maybe. We'll see how that goes. That's bold. That is a bold assessment there. So somebody's lying here. We'll find out who it is. Now, action items. This is what I want you guys to take home. Please take a screenshot of this. Write it down. Pull every BAA you have. Review those indemnification clauses. If you don't have a liability cap, see if you can renegotiate that BAA. Third, audit your service scope against each BAA. Make sure you are doing what you are supposed to be doing per the BAA. Is the client gone? See if you can get a signed service termination, right? Cut that BAA out. Please, moving forward, do not sign any BAAs without legal review, or you could end up in one of my videos. Next, get your tech E&O insurance in order. 7, document your controls against a recognized framework, because that, as you heard earlier, is going to get pulled into this court case. You want to make sure you have your ducks in a row so you don't look like a rookie. Have an incident response plan. It may be evidence. It's probably going to be evidence inside of this video. Now, if you've spoken to me before on the phone about your insurance, I've probably said, hey, I don't really care if you have an incident response plan. You're going to know what to do. This changes that. My recommendation moving forward will be have an incident response plan. It could be used as evidence. Next, require your clients to carry their own cyber coverage. Now, if I'm reading between the lines here, it doesn't sound like MTL had their own cyber policy, because why? Well, hell, they didn't need one because they got this MSP to effectively say, hey man, we don't need cyber insurance. We'll just use yours. Now the MSP is staring down the barrel of $5+ million of liability. Not a good position to be in. All right. So please, if you haven't already, contractually require your clients to carry their own cyber coverage. As for actual BAA clause considerations, I wish I could give this to you guys on the internet, but it is the internet and people from all over the world watch these. So that will only be for my own insurance clients. You can get that from me. All right, guys. Hopefully that helped. Not trying to scare you, just trying to show you the rules of the game here. Please like, share, comment, subscribe. Let me know if you have any additional questions. Right above me here is another video that the YouTube overlord. If you click on my face, you can subscribe to my channel. All right, guys, with that, stay safe.